concerning update in a case in Michigan that involves, the AP is reporting 15 fake electors from 2020. The judges just made a decision on this case in particular. Can you explain what just happened?
Yeah, Brian, this one is perplexing. A state court judge in Michigan just threw out the cases, threw out all of the prosecutions against the fake electors. Now, these are people who forged certificates attesting falsely to the claim that Donald Trump won the 2020 election in Michigan when he clearly lost the 2020 election. These people were indicted on 8 felony counts each, including forgery, which they certainly seem to commit, conspiracy, and several other felonies. Indeed, the Attorney General, Dana Nessel, announced that, this plan, this conspiracy that they were in was designed to reject the will of the voters and undermine democracy. It was fraudulent. It was legally baseless. And I will add, it was criminal. For some reason that doesn't make any sense to this old career prosecutor, the judge just threw out the case. So all I am left to do, Brian, is quote for our viewers what the judge said. And there are a couple of real curiosities and problems with what the judge said. The judge's name is Kristen Simmons, and she said, quote, "This is a fraud case, and we have to prove intent. And I don't believe there's evidence sufficient to prove intent," Judge Simmons said from the bench Tuesday in her Lansing, Michigan courtroom. Now, let me explain to our viewers why there's something very wrong about that. First of all, let me start with the procedure. She announced this off the cuff from the bench. There's no indication that there is, a very thoughtful, detailed memorandum of law with her factual conclusions and her findings of law as to why she decided to dismiss felony charges against more than a dozen fake electors who tried to undermine democracy, undermine the will of the Michigan voters. That's a procedural curiosity to me. This should be a dense, lengthy, written opinion that sets out her basis, her rationale, and the precedent she's relying on. But here's the more fundamental problem I have with this, and I'm going to use an analogy to try to make it a little bit more understandable to lay people who are fortunate enough not to be lawyers. Yeah. So let's assume that you have a case where somebody falls onto the railroad tracks at a subway station and is run over by the train and dies. And the evidence established that the person who caused the victim to, tumble onto the railroad tracks pushed that person, but then they claim, no, really, I kind of stumbled and inadvertently fell into the person. And so the question becomes one of intent and motive. Okay, what does the evidence show with respect to what that person really did? Was this an accident, which is a defense in the law, or is this a murder because they intentionally pushed the person onto the railroad tracks? Let me add to the factual hypothetical that if you knew that the person who was claiming this is all some kind of an accident, a misunderstanding, was also somebody who was deeply upset by the fact that the victim had just won an election and wanted to make sure that person couldn't take office. That, Brian, is evidence of motive and intent, and it might very well color a jury's perception of the claim that, oh, no, this was just some kind of an accident, just happenstance. And Brian, that's why we have jury trials, to decide whether intent can be proved beyond a reasonable doubt by the prosecutors. You know how we don't resolve criminal cases like this, where electors fraudulently signed official documents that were designed to do what? Well, we know what the scheme was. We learned all about it. These fake elector certificates, fraudulently claiming Donald Trump won, were supposed to go to Washington together with the true elector certificates reflecting Joe Biden's win. They were supposed to send Congress into chaos on January 6th, with the scheme being that the decision would be thrown back to the states and it would come down to a simple vote, one vote for each state as to who won, with the Republicans in control of more state legislators and governors' offices so they could undermine the will of the people and use this alternate means to try to install Donald Trump unlawfully and unconstitutionally. The fact that this judge would say, I don't know that there's enough evidence of intent. Well, with all due respect, Your Honor, that's a jury question. That's why we have trials every day. Judges don't look at the evidence in advance of trial and say, no, I'm not satisfied that there's enough proof of intent. That's not the way the criminal justice system works. And I find it intensely curious, to put it mildly, that this judge tossed this case out on that basis.
So basically, the judge precluded the trial from even moving forward where it was supposed to go, which was to a jury. Is that correct?
Exactly.
And so is there any recourse here? I mean, I know that we can talk about the prospect of appealing this up to an appeals court, but we have this judge unilaterally deprived the justice system of allowing a jury to sit and actually hear this case. So is there any recourse even for the trial court?
Yeah, there is recourse in that Attorney General Dana Nessel has already gone on record as saying that the state is exploring all options, including the possibility of appealing the judge's dismissal. So to get down into the criminal justice weeds here, double jeopardy is not a problem yet. You know why?
Because the jury hasn't sat.
Jeopardy doesn't attach. See, you've learned the law well during our legal breakdown law school classes. Jeopardy doesn't attach to a case until the moment the jury is sworn in by the judge, by the court. It doesn't have to wait for opening statements or for evidence to be introduced. It's the minute they take the oath and swear that they will do jury service fairly and impartially without fear or favor, and render a decision based only on the facts and the law as the judge instructs them on the law. So jeopardy hasn't attached yet, but more fundamentally, when a judge short circuits even the opportunity for the people of Michigan to get their day in court through the work of the prosecutors who represent the interests of the people of Michigan, when the judge tosses it out before it can even get to the jury trial phase, then the government, the attorney general and the prosecutors have a right to appeal. So I strongly suspect that the prosecutors will appeal, and then, maybe they can sort out what it is this judge did by making herself the jury and concluding that even though the trial hasn't been conducted yet, there's not enough evidence of intent. You can see how I'm struggling to make this make sense.
Are there any other analogous cases in other states where this process has actually moved forward?
Well, I mean, we can look to the other states where there have been election prosecutions brought. Down in Georgia, we know that thing has come to a grinding halt.
Right.
Why? Well, because of the presidential immunity ruling and because there was an issue about the district attorney, Fani Willis's independence and ability to continue to be involved in the prosecution. That feels like a hot mess, at least on the procedural front at this moment. It is still a live case, but it seems to have stalled in the appellate courts. There's a prosecution out in Arizona based on an election challenge and crimes that were allegedly committed and have been indicted against multiple people in Arizona. That one seems to be moving forward. I believe there's a case in Wisconsin. So there are still criminal cases kicking around. And I suspect your next question may be, will what happened in Michigan have any precedential effect with respect to any of these other prosecutions that are still up and running in other states? And the answer is really no. I mean, in federal court, if one jurisdiction decides something, it can be kind of persuasive authority to another federal jurisdiction, but the states are all independent sovereigns. So I suspect this ruling will not impact the other criminal prosecutions that are up and running around the country.
Well, on the flip side, can Dana Nessel and these Michigan prosecutors actually point to the fact that prosecutions are moving forward in other states as a way to kind of negate what this judge opted to do on the bench here?
Yeah, good question. The answer is probably not. Why? Each state, being its own sovereign, has its own body of laws. Now, that is both the statutes that they have and the appellate court opinions that become precedent, but only in that state. And those appellate court opinions will evaluate and fine-tune what the prosecutors can and can't do under those state laws. So it really won't have an impact on how this case proceeds in Michigan. But I think what will most directly have an impact is what I believe is the strong argument that Dana Nessel has, that judges are not the finders of fact in a jury trial. They don't get to say, you know, I don't think there's enough evidence of motive. And the reason they especially don't get to say that on the motive front is because there's a standard instruction of law given in virtually every jurisdiction in the United States, local, state, and federal, that tells the jurors, ladies and gentlemen, there is no way to look into the workings of the human mind and determine what somebody's motive is. There is no test that can be run. You know, you can't just give somebody an MRI and spot their criminal intent or their motive. That's why when it comes to criminal intent, you, the jurors, get to infer intent from conduct and circumstances and statements of the defendant. It is so intensely and exclusively a question for the jury to resolve that, you know, I will again say that this is beyond curious. It feels dead wrong from the perspective of a career prosecutor.
Well, we will, of course, stay on top of this. If there are any updates on this case, we'll, of course, bring them to you. If you're watching and you'd like to stay on top of this legal news and other legal news, please make sure to subscribe. The links to both of our channels are right here on the screen. It's the best way to support our work. It is completely free and a great way to support independent media. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.